Pakistani high courts and the jurisdiction of rights, Article 199. An essential part of Pakistan's legal system, the writ jurisdiction of high courts, will be covered in this lecture. The authority to issue 5 vital writs to guarantee justice and protect basic rights is conferred upon high courts by Article 199 of the Constitution. Explain writs. When an aggrieved party files a petition with a high court, the court will issue official commands known as writs. Public officials are compelled to act legitimately or are prevented from exceeding their jurisdiction by these writs. They are potent instruments that people can use to fight back against the state and defend their rights. High court writs, 5 different sorts. Habeas corpus, you shall have the body, is the Latin translation. The purpose of this is to bring the person who is being held unlawfully before the court. Use this writ prevents arbitrary imprisonment without a warrant and safeguards against unlawful arrests. The court can release someone from detention if there is no valid reason to do so. We command is the Latin word mandamus. Goal: to make an agency or government entity carry out an obligation that is required by law. Application: when a government agency is unable to meet its responsibilities, this writ is utilized. For example, a writ of mandamus can force a government agency to provide a license if they have unlawfully refused to do so. Prohibition: to forbid in Latin. The purpose of this provision is to ensure that lower courts and tribunals do not abuse their jurisdiction or commit unlawful acts. Application: lower courts proceedings are halted by this writ when they go beyond the boundaries of its jurisdiction. As a result, subordinate courts are prevented from abusing their authority. Certification: to be certified in Latin. The goal is to have a case reviewed by a higher court after it has been handled in a lower court. Application: the high court can review and, if necessary, reverse lower court's decisions that were not based on sufficient legal grounds. By issuing this writ, it fixes mistakes made by subordinate courts about jurisdiction or laws. A Latin phrase meaning by what authority is quo warranto. The goal is to determine whether or not a candidate's claim to public office is legitimate. The purpose of this writ is to ensure that only suitably competent individuals are appointed to public office. This checks to make sure that only people who are qualified by law can hold those positions. Real-world examples: if someone is being held without a warrant, a family member has the option to seek a petition known as habeas corpus mandamus. This legal document can be used to force the issuing of a passport if an application for one is denied, even though it satisfies all conditions. Prohibition: a lower court can halt proceedings with a writ of prohibition if it is treating a case outside of its jurisdiction. A higher court can review and possibly reverse a lower court's decision that was based on faulty legal grounds through the use of certiorari quo warranto. This writ has the authority to challenge the appointment of an individual to a public office if they are found to be unqualified for that position. Why writs are crucial. Maintaining Pakistan's rule of law depends on these writs. They make it possible for citizens to hold the government accountable when it breaks the law and ensure that public officials do not overstep their bounds. A just legal system and the protection of basic rights are both ensured by writs. In sum, Pakistan's legal system is based on the writ jurisdiction of the country's high courts. Anyone wishing to traverse the legal system and guarantee the protection of their rights must have a thorough understanding of the 5 writs: habeas corpus, mandamus, prohibition, certiorari, and quo warranto.